All right. Giving people just last moments to find their way to this session or the other one. All right. So let's get things going. I am pleased to introduce back Teresa Anderson and also Steve Dale, who is a chair, on the board of directors for the ARC of California, and Suzanne Bennet Francisco, who is an expert in supported decision-making and also a mother, who will discuss conservatorship and supported decision-making now and in the future. And we're going to have each of our speakers introduce themselves. And Teresa, I believe you're going to kind of moderate the discussion. So I'm going to hand it over to you, Teresa. Welcome, everybody.
All right. Welcome, everyone. Welcome to our session on conservatorship and supported decision-making. We are very glad that you're here. As Jordan said, my name is Teresa Anderson. I'm the Public Policy Director for the ARC and United Cerebral Palsy California collaboration. And there's a lot to cover in the next 40 minutes, so we're just going to jump right in and start with the fact that recently there's been a lot of attention given to the issue of conservatorship, and much of the driving force behind that attention was a highly publicized case in the media. I think we all know the Britney Spears conservatorship case. And while this session is certainly not about Britney Spears, we are glad that more attention is being given to those issues of conservatorship and really the continuum of alternatives to conservatorship, including supported decision-making. And what we do know is that every person and every family is unique, and there's really no one-size-fits-all approach to the very, very complex issue of conservatorship. We hear stories from families who are told that they cannot attend IEP meetings or IPP meetings unless they have conservatorship of their adult child. And we also hear from families that, they don't know what their options are. So the reality is that there's a lot of misinformation out there about conservatorship, and we need to get more accurate information out there. So some of the big questions, who should be conserved, when they should be conserved, why they should be conserved. That's all information parents, families, loved ones should have access to and should know. So providing accurate information is really, really important. And that's what we're hoping to give a little bit more today. So there's definitely circumstances where we know it's necessary, but there's also many circumstances where it may not be necessary for the person to be conserved and where alternative supports can be appropriate. So I am very excited that we have two experts here today, Steve Dale and Suzanne Bennet Francisco, to discuss the continuum of supports that are available to individuals and families. Each speaker will have 15 minutes, and I will, if you guys can see me, I'll try to help moderate time. Maybe I'll hold up, 2 fingers for a 2-minute warning or something like that, but we'll get through this together, and I will now hand it over to Steve.
Okay, now hopefully you can hear me. I have an indication you can. Well, yes. Okay, we're doing good. So, okay, and thank you for the introduction. And I guess I feel the love from my fellow advocates at the ARC. Nice to include an attorney once in a while. Hey, what I want to talk about here, and I'm really excited about this, is talking about conservatorships and really about decision making and the development of how we got here and what this is all about. I'll give a little introduction about myself here. I am on the board of the ARC of California and a bunch of other boards as well. I have kind of a unique background in that I come from a family of institutional workers who worked in California state hospitals, some of them later called developmental centers, here for 3 generations. I actually was a psych tech for 17 years and was also the union president of Sonoma Developmental Center during the COVID years as well. I eventually left state service and nursing here to become a civil rights attorney, and I was honored to do an internship here for a number of years at the Disability Rights Education and Defense Fund here at a very magic time when IDEA was being passed, and the ADA. I like to think of myself as the Forrest Gump of disability rights. I didn't do these things, but I was in the background here. And it helped me develop, once again, my lifelong passion of working with folks with disabilities. After working at Dredif, I opened up a law firm that focuses entirely on planning for persons with special needs here. And with that, we do a fair amount of conservatorships. I'm also the trustee of the Golden State Pool Trust, just to give you some background of where I'm coming from. So let's go through a little history. And next slide, please. Okay, so how did we get here? And I think it's always useful, to look at this from a historical perspective. And as we start talking about conservatorships and supported decision making and things like that, I think getting him some historical perspective really helps. Next slide, please. And I am going to say something here as we go through some of these observations. You're going to see some antiquated language that is not appropriate today. We all know the R word is something we don't use and all of that. But, it's still, I think it's important to, as we move through this whole thing about community living, to understand the history. Next slide, please. So part of community living, and in many ways, it comes from institutionalization. Okay. And institutionalization in the United States started very, very early, even before the Declaration of Independence here. So as we can see, the first institution in the United States was in Virginia here. And by the way, they were meant to really provide care in what they felt was the best way possible. Now, these are all antiquated here. And as we go through this, it's not that I have a fondness for institutions. In fact, even if we did, they're antiquated. They don't fit our needs. But it's good to understand that. Next slide. California, once again, had a robust system. And the thinking in the days when they first started in California, as we'll see here, it was in 1875, was to establish farm programs, farm systems here that usually had large Victorian buildings and basically were agriculturally based here. And were there to provide asylum. Once again, this is how they were done at that time. They actually, until the 1950s, actually turned a profit. And I'm not saying that's a good thing, because that was, with the inmates who were providing the care here. But that's how they did it in those days. Next slide, please. So there's a big change that happened in the 1950s, which is the movement from the farm system to the medical model. And a lot of that was done through a medication called Thorazine. If you think about it, it would have been very difficult to lock people up in big cement buildings here before these medications. And with these medications, which, did have some positive effects, but on the other hand, they were often used to sedate people. And I will tell you, when I worked at Napa State Hospital, we gave huge amounts of medications to control folks and that kind of thing. And that put us into a darker period where, once again, in the movement towards the medical model, not only did we learn about medicating, some would say over medicating, lobotomies and things like that, in an attempt to try to eradicate mental illness and in many cases developmental disabilities here by treating folks as if they were a medical problem. Let's go to the next slide, please. Big change was in 1963, and this is one of those things. If you ever get a chance to read this, hear about this, this was really a tremendous move. In 1963, President Kennedy made a challenge to the nation here that in 10 years he wanted to shut down all institutions and move all of those funds into the community. Unfortunately, after his assassination here, They lost sight of what the goal was. And yes, a lot of the institutions were shut down, but the money did not move with it. Okay. And we're going to see a disparity coming up as far as how it affects California. Next slide, please. California, being a leader in this area here, put together the Lanterman Act here in 1964. And part of that was the focus on dealing with folks with developmental disabilities, which is certainly our focus right now here. And part of that was the growing need to expand care. And the big push was, were we going to expand the institutions, or were we going to do something else? Next slide, please. So once again, funds were appropriated for 2 regional center programs, one in Northern California, one in Southern California, as a grand experiment. I know many people here that worked in the institutions felt that, you know, this was not going to go anywhere. Well, they were certainly wrong about that. And that led to our robust system, which, by the way, came because of advocacy of persons with disabilities and families. Next slide, please. So with that, unfortunately, and we see this happening, well, in 1967, once again, Governor Reagan passed the Lanterman Short Act, which once again focused on putting together a patient's Bill of Rights here to help work on how we were going to work with folks in the community and how we were going to grant them certain rights and that kind of thing, and to expand on community services. And we then see the amount of folks that in state institutions plummet. By 1973, it was down to 7,000 people. Next slide, please. 1981, unfortunately, President Reagan then defunded many of these programs here by once again, and a lot of the problems we see over and over and over again is the constant moving of the funding from the state to the federal to the community and whatever. And we saw this erosion of mental health programs here. And so, for instance, any of us in any large city can go almost anywhere to see this. In San Francisco, big surprise here. We have a huge homeless population, of which many of folks are have severe mental illness. Next slide, please. So the other factor as we start talking about limited conservatorships is California's history with eugenics. Next slide. And we're going to have to move a little faster too. So Indiana was one of the first states to do this. And this was basically here to sterilize folks who were not considered normal here. And California became a big part of this. Next slide, please. So California was very involved in this and had tens of thousands of folks that were sterilized. And this is something that the civil rights folks later really focused on about not repeating that history. Next slide. And we're going to power through these. As it says here, Hitler was a big fan. In fact, he specifically focused a lot on what was going on at Sonoma Developmental Center, which was a center for a lot of these things happen. Next slide. So let's get back to our subject is conservatorships and supported decision making, but it really is the challenges of community living. Next slide. So as far as the history of conservatorships, because the whole issue is not only moving the services into the community, but for folks who were unable, or at least perceived to be unable to make decisions for themselves, how are we going to do this? California adopted its first conservatorship bill in 1957. Before 1957, you could actually be conserved. You could actually have your civil rights taken away without a hearing, without a notice. They didn't even invite you to give your side of the story. Next slide, please. As it developed here in 1967 under the Lanterman Short Act, Once again, there started to be developed something specifically for folks with mental illness and developmental disabilities here. And it developed a new standard for anyone who was considered gravely disabled here. A series of, once again, giving power to somebody to make decisions for folks who were at least perceived to not be able to make decisions themselves. Next slide. So in 1980, it created the limited conservatorship specifically for folks with developmental disabilities here. And the concept of this, as it is still today, was to try to give just the right amount of power, not too much, not too little, but that was the concept. Next slide, please. So with that, and we're going to power through this slide. Let's go to the next one because I want to leave as much time for Suzanne as I can. So part of that is, and you need to hit the slide button there. A limited conservatorship is a protective proceedings, and it's done through the courts because we're dealing with people's civil rights. Really, a limited conservatorship is taking away somebody's civil rights, which is something we should take very, very seriously here. And it's supposed to be for a person with a developmental disability in a situation where they have a substantial impairment and that they're unable to care for themselves or their property. Next slide, please. So, and just power through the seven, there's going to be 7 powers that are going to pop up. So you need to hit the button 7 times. Okay, so as we go through this, 5 more times. There we go. Sorry about that. 2 more. So the concept was, and we still have this today, 7 rights that are focused on. So anybody who's been through a conservatorship process or whatever, what they're looking for is the process is what rights is it the conservator needs to have, and what are the ones that should be left with the person with the disability. These are the 7 rights. One thing you'll notice, the right to control social sexual contacts and the right to about making consent for marriage. Remember, I told you a big focus on this whole thing was the fact that California had a shameful history of eugenics, basically sterilizing folks merely because they belong to a class. Next slide. Okay, what powers are restricted, and you just need to power through the next few things too. You can't commit somebody to a locked psychiatric facility with an LPS. You can't give them experimental drugs here. You can't give them electroshock treatment here, and no sterilization. Boy, if we had a lot of time, we could talk about, well, how did they do it with Britney Spears? And the answer is, I have no idea, because there hasn't been a legal sterilization done in 30 years. Next slide, please. So let's just talk for I'm probably going to go over like 2 minutes, Suzanne, I'm sorry. So let me give you my thoughts about AB 133. Next slide, please. I think we have. One is, I don't want to be an apologist for our conservatorship system. Our conservatorship system in no way is a well-oiled machine. This is something the ARC of California has been focused on for some time. Our system is desperately in need of reform. And this is not an easy subject, is it, Teresa? This is what is truly a third rail subject, meaning if you touch this thing, you're going to get fried. So it's going to take some a lot to be able to tackle these things. And these are not easy issues. You know, part of what we're looking at is balancing between a system of due process and allowing folks with disabilities to make their own decisions, even making bad decisions here. But it's balancing that against under what situations do we need to grant someone, the conservator, the right to make decisions because it's in their best interest. These are not easy discussions, and it's going to be different from person to person, group to group. Next slide, please. Okay, so as we all know, and I want you to keep this in mind, especially you self-advocates out there, because you're not advocating just for yourself, you're advocating for the community. Same thing with the families. Persons with developmental disabilities, persons with any disability, persons in general here, they're individuals, right? Our community is diverse. You know, for myself, if everybody with a disability was the same with the same needs, it would make my job so much easier. Teresa, it would make your job easier too. But that's not what we're dealing with here. We're dealing with individuals, and all of that. The other observation, this is one of my hopes, is that in order to do this properly, I believe that excluding the professional community is a mistake. Next slide, and I think it's our last. So there is a need for reform and inclusion at all levels. And next slide, please. Here. And my belief is the Arc of California is in a unique position to facilitate that change. It's going to take a lot of courage to do this because people are very emotional about these things here. And we tend to look through this through the prisms of our own lives, which is different for many of us. But in my opinion, change is only going to happen when all stakeholders come together. One thing, and I want to turn this over to Suzanne, who is a fantastic advocate. I do want to point out something. This is a wonderful conference. I'm going to ask if you are an attorney who does work in this area or a fiduciary, will you put your name in the chat or just say hi? And I'm going to guess we're not going to get a lot of folks. The thing about it is we are all involved in this. Families, persons with disabilities, advocates, professionals, support workers, and all that. And we all need to come together to work for the same thing, which is to help all folks with disabilities live the best quality of life possible and be able to make their own decisions, maybe even to make their own mistakes. Suzanne, so good to see you.
Hi, everyone. Thanks so much for sharing, Stephen. I really appreciate it. Teresa, is there anything that you needed to say before I begin?
Super excited to have you, and let's just keep this conversation going. So take it away.
Great. Thank you so much, Stephen. He is a wonderful advocate for supported decision making as well. So thank you for all that you shared and the humanity of it. It's very important to remember. So I'm Suzanne Bennet Francisco. I'm president and CEO of Exceptional Rights Advocacy, and I'm a parent to 3 adults who have developmental disabilities. They have congenital muscular dystrophy, autism, and they're kind, they're cunning, they're non-speaking, and they use AAC devices. I'm also the TASH Human Rights Committee co-chair. And I am the sister to a woman who had a disability. And I use supported decision-making, which is an alternative to conservatorship I'm going to talk to you about, with my sister in her end-of-life care, and use it currently with all 3 of my children who are not conserved. So if you can go to the next slide. I'm sorry, it's a little small print for me, so bear with me. I'm getting up there now. I want to make sure that I mention that I'm a non-attorney, but that this presentation has been informed by many disability rights attorneys who have informed what I'm sharing with you. I've worked with lots of agencies and in collaboration on grants given for supported decision-making. In fact, I've worked with the Arc of California. I've worked with Disability Voices United, and on projects where I spoke in Northern and Southern California on supported decision-making to parents, to self-advocates, to community leaders, to healthcare leaders, and to legal services representatives as well. I want to make sure to tell you that what I'm here to do today is to tell you about different options. I do education and training, and so many of us have no idea that there are other options. So we're never here to disparage any parent that has already conserved their child. And in fact, we emphasize that that's generally all the information that we get. So I want to make sure that you know we're here to educate people. That's my intention. Next slide. So supported decision-making is what we do every day. When we need and want help, we seek out doctors and mechanics, friends and mentors, and we're seen as wise for that. And, I just want to point out, like in the case of a doctor, we never know what the doctor knows, right? We know that we trust the doctor, we chose that doctor, and we say, gosh, can you explain this to me plainly. And he says, oh, you can take medication or you can have surgery, and you may sign a form. And that's a way that we probably don't know everything that that form says, but we have chosen someone to support us, and we're seen as wise. So we just really need to realize that people with different abilities are held to kind of a Dr. Spock standard that the rest of us are not. They should have access to the same support that we have. So everyone practices supported decision making, making choices with the help of chosen trusted supporters, family members, friends, professionals, and according to each of our unique abilities. As Stephen pointed out, we are all unique. Next. So this is where we're headed as a culture. We have the respect and recognition and mindfulness of ableism, where people with disabilities are discriminated against at times, and also of the UN Convention on Rights for Persons with Disabilities that says that state parties shall take measures to provide access to persons with disabilities to the support that they may require in exercising their legal capacity. And that is a really great document that says a lot of other really empowering things for people with disabilities you may want to check out. And of course, home and community-based services, which allows people with disabilities to participate in and experience life in settings in the community with and like those that of our non-disabled peers. And I think they're trading out the interpreters here. Hi, welcome. So also IDEA, the Americans with Disability Act, and the Lanterman Act all have built into it systems that are perfectly in line with supported decision-making, self-determination, person-centered planning. And I will tell you, I have a lot of slides today, and usually I go into IEPs, IPPs, employment, and that in a more detailed way, where we go through how we can write the goals and the areas of need. So I'm going to skip some of this, but there is access to a link at the end when you get these slides of a full and complete presentation on this that actually includes a self-advocate who I've helped speaking as well. So next slide. So as I said, we're in an era of supported decision-making. It's a flexible option available to adults with disabilities that empowers them to use maximum autonomy with voluntary support options and chosen trusted supporters to assist them to understand, communicate, and implement preferences and choices. And so I realize the date here is incorrect. These are the state laws as of today. Currently, there are 18 states that recognize supported decision-making in legislation and regulations or resolutions. Again, I think Teresa mentioned in the last session that AB 1663 is a proposal for conservatorship reform and supported decision-making. And I will touch on that a little bit in the little bit of time we have to share everything I'd like to share with you. Here is a link to 2 pieces of information on state legislation, case law, court orders, and supported decision-making pilot projects. And the second one there really has a lot of information about pilot projects on supported decision-making in New York, in Massachusetts, in Virginia, and other states. So we have research and data on supported decision-making. Next slide. So the least dangerous assumption is to presume competence. And I heard this statement by somebody who is involved in leadership and employment. You never know if someone can run with the ball if you never hand it to them. And really the question for ourselves is, how often do we actually hand the ball to people with disabilities? And so we need to be reminded of that. And in DC, in schools, they have supported decision-making built in starting in preschool. So, you know, this gives us an opportunity to think about the ways that we may inadvertently steal away skill building opportunities for anyone, even for a typical toddler or for anyone in our life. So supported decision-making is really a paradigm and a practice and a way of thinking. And I really realized with my non-speaking children that my middle son in particular, I presumed him incompetent. I really thought that I knew what he knew. And I would walk around the house asking rhetorical questions of my children. And one day he answered the first time he shook his head, yes. And I was like, Yes, I don't think you could possibly understand what I said. I rephrased the question in many different ways, and he answered the same every time. So that was really a light bulb moment for me. And I love the way the Council on Quality and Leadership, CQL, explained the presumption of competence in plain language. So there's a link to a video here, and they talk about how presuming competence does not mean that we sit back and watch people in extreme or unsafe situations, and that it is our job to be there to offer support, but not to be a roadblock to happiness, to learning, or to life experiences. Next slide. So everyone is entitled to the least dangerous assumption and the presumption of competence. And that includes non-speaking people like my children. That's my daughter Kylie and my son Blake. And they use communication devices, alternative augmentative communication, as you have heard it called, AAC. And so we can use dream board collages, person-centered plans, and social programs and stories for them to understand and to communicate their choices. And if I have time, I'm going to show you some examples near the end of the presentation. Next. So supported decision-making can be included in legal binding documents. And I think there's a lot of, I think what I really want to emphasize is that supported decision-making is exactly that. It's about offering people voluntary supports, and that there is a circle of support there. And you can build that into an individualized education plan, an IEP, an IPP, medical and financial powers of attorney, advanced healthcare directives, HIPAA insurance authorizations, SSI rep payee forms, and other voluntary supports that are also legal binding documents. And so for an IEP, my son can say, I want my mom to help me with school, and they can write that directly in the IEP notes, or it can be included in an area of need, or it can be included in an IEP goal. But it's as simple as that. Someone can write on a HIPAA form, you know, I want Suzanne to be included as my supporter and have access to my information. And written in a way that reflects their communication as well. So that can include visuals. And IPP and employment plans can also include supported decision-making. And in the case of my children, they have supported decision-making goals, and they have person-centered planning goals. So we do not have conservatorship, and we practice it without issue with all three of my children, actually. And so I think this is a piece of misinformation that you have to conserve your child and that you can't practice supported decision-making with legal binding documents. And this is part of one of the grant programs that I participated in. We created this handbook at Disability Voices United called With Support and Without the Court. And there's lots of really great plain language information about what these documents are, how they can be used, and plain language forms that you can adapt for your loved ones. Next. So why is supported decision-making important, and are alternatives required prior to conservatorship? And the answer is yes. And actually, in 39 states, there are least restrictive alternative requirements. And so in California, basically a person who's going to conserve somebody must consider those prior to the commencement of any conservatorship proceeding. And we're really concerned, and this is important because there's kind of an automatic flow where parents hear overwhelmingly through schools that they have to conserve their child. And so many times, including in my case, I wasn't told about any alternatives or that this was even included in the law. And so one option by definition is not a choice. So we really want to educate people and let them know how they can practice supported decision-making. And the National Guardianship Association specifically, and many other disability agencies have had position statements on supported decision-making. And they say alternatives to guardianship, including supported decision-making, should always be identified and considered whenever possible prior to the commencement of guardianship proceedings. So this is, it's a universal understanding across the United States that conservatorship is supposed to be the most restrictive and last option. Teresa, are you okay?
Yeah, I'm just giving you the 2 minute.
2 minutes. Oh my goodness. Okay, we're going to go really quickly. Okay, so if you can go to the next slide. So self-determination and the self-determination program in California goes hand in hand with supported decision-making. And that's where somebody has choice and control. And so that is a best practice in special education. And you can kind of skim through the next slides. And we know through 40 years of studies that people who have greater self-determination have better psychological health, they're healthier, they're more independent, well-adjusted, and better able to recognize and resist abuse. In fact, women with intellectual disability are able to recognize and resist abuse, according to studies. When they have increased self-determination, they're more likely to recognize and resist abuse. So there are ways that we can contrive opportunities for people with disabilities to practice dating and to learn those safety options. So Stephen spoke about this. These are the rights that can be taken in a conservatorship. If you can go to the next slide. So we know rights and choice are equal to self-determination, and that's being a causal agent rather than being acted upon. And there have been studies, we know, when people are denied self-determination, that they are likely to feel helpless or hopeless or have passivity in their lives. Next. So without a guardian, study shows that people with intellectual disability are more likely to have a paid job, live independently, to have friends other than staff and family, and to go on dates and practice the religion of their choice. So there's several misconceptions I'm going to run through really quick. One of them is that we feel like we have to conserve our child, and we're here to tell you that there are other options that should be considered, and there's rather an automatic flow into that system. Supported decision-making fits into existing systems. Go ahead. Another misconception is that people are able to retain their rights, and we shared that they are not. In many times, all 7 rights are taken even under a limited conservatorship. And we know that it's not easily undone, and people have the misconception that they can just change and exit a conservatorship, and it's extremely hard. It's an uphill battle. Next. So another misconception is that they have fair representation if they're trying to get a court investigation about their conservatorship. And Congressman said that a person with a disability often has fewer rights than a felon because even though they are supposed to have fair representation, it often doesn't happen. And often the public defender may not speak to the person directly, as is in the case of the self-advocate that I work with directly. And you can keep going. I wanted to also point out that a conservator is a court-appointed conservator. So without question, the power belongs to the court. And so they may decide that the family member is not the appropriate conservator, and they might assign an unbiased conservator. In the cases of divorce, if there's a disagreement between a man and a woman, they're not going to handle family issues in the probate court. And another misconception is that the conservatorship will necessarily keep them safe. Many people in isolated congregate settings that are abused are already conserved, and it also doesn't protect from law enforcement. If I can go through a couple more things, keep going. If you can go, basically there are professionals, and this information should be available to you. You can keep going. I think she already reviewed AB 1663, but it basically makes these voluntary supports that I talked about, supported decision-making, powers of attorney available. And you can identify supported decision-making in these documents. This will be available to you as these slides are available on the very last slide with resources. And if you can go to slide 49. So this is a supported decision-making agreement example that's in the handbook. It defines who the supporters are and how they will support the person. If you go to the next slide, please. These are examples of documents that you can use to support somebody with supported decision-making. Next. And I just want to give some examples of tools that you can use with people who are non-speaking. So if you can skim the next few slides, that would be helpful. So there's a communication bill of rights. We can put social stories right into communication devices. This talks about who the supporters are and how they support that person in each area. This is a one-page profile in a person-centered plan. This is a dream board. A person used this to terminate their conservatorship by using this as evidence for a judge to understand her dreams and her wishes. So these can be really important tools. Social boundaries programs, and obviously I don't have enough time to say everything that I wanted to say, but there's lots more information about this. And what I want to point out about supported decision making is that it creates a circle of support. And with supported decision making, we are not alone. So many times people are really feeling fearful as a parent, and supported decision making just creates a larger team that knows everything about your child. And so there are resources. Go to the very last page. That's the last thing I want to say. That's my daughter. The very last page, that was it. It has lots of resources. It has a video with a full presentation, a one-page overview that you can click on supported decision making. There's videos of Marie Burgum, who is a self-advocate conservatee, who I worked with, and lots of other references there. So thank you so much. I'm sorry I spoke so fast for the interpreter. Thanks for listening. If you need any more information, my contact information is there. I hope everybody gets these slides, and feel free to reach out to me and ask questions.
Thank you, Suzanne, so much. We really appreciate this. A lot of information between you and Steve. So grateful that you guys had the opportunity to share. We unfortunately don't have time for questions right now, but they are going to be posted in the chat. So we will try to answer questions or get people resources. And a lot of that will be on the slides that you shared. So thank you very much. And I believe it will go